Hello everyone and welcome to today's video. Our featured guest is a sovereign citizen who simply cannot avoid defeat, and at this point it has become a predictable pattern. When someone builds their world on arguments that never work, they end up taking loss after loss, and today is no different. We have 3 separate cases to walk through in a total of 6 hearings that show exactly how these situations unfold inside real courtrooms. Each hearing highlights a new layer of confusion, a new misunderstanding of the law, and a new attempt to escape responsibility. So settle in as we break down every moment and explore how the justice system handles claims that fall apart the second they are tested. Let us get started.
We are on the record with file number 22-186783, J.P. Morgan Chase Bank versus Marcus Campbell, date and time for pretrial. Appearances.
Good morning again, Your Honor. Jim McCardle on behalf of J.P. Morgan Chase, P number is 82443.
And your name, sir?
My name for the record is, I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendant, virtually none of which I understand.
It is all right, Mr. McCardle. When a document is built on ideas that have no real meaning, the result is naturally confusing. No reasonable person would expect you to make sense of something that was never grounded in clear thought to begin with. The individual who filed it does not understand what they wrote, and even the person who convinced them to use that approach likely does not understand it either. In situations like this, the court is simply left sorting through a pile of statements that sound important but collapse the moment they are examined. The goal now is to guide the case back toward real law and real procedure, so everyone can move forward.
So that's, as far as I'm aware, what the status of the case is.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just answered. I sent the brief.
I asked you if you received his motion for summary disposition.
Yes, I have.
Okay. So then I'll just calendar it. That's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something.
What
I
is
did
that,
respond.
sir?
I did respond to the courts and to the complainants.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of the public to bring this to me.
All right, so you are requesting discovery. However, that process only begins when a motion is correctly written, filed, and served according to the rules of the court. You will need to prepare a formal motion that clearly states what information you are seeking and why it is relevant to your case. Once the document is submitted in the proper manner, the court can review it and decide how to proceed. Proper procedure ensures that both sides have access to the same information and that the case moves forward in an orderly and fair way.
Sir, you can file whatever motion you want. Right now, I'm going to calendar Mr. McCardle's motion for summary disposition. That if you want, you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock. We are going to call file number 22-186783, J.P. Morgan Chase versus Marcus Campbell, date and time for a motion for summary disposition. Could I have your appearances?
Of course, Your Honor. Jim McCardle appearing on behalf of J.P. Morgan Chase.
Bar number?
82443.
And your name, sir?
Marcus Campbell in special appearance.
Mr. McCardle, this is your motion.
Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22, and then we subsequently filed our motion for summary disposition on 12/15/2022.
This case has been moving through the system since May of 2022. and it is remarkable how long some of these matters can stretch when procedural delays keep stacking up. Individuals who rely on unusual legal theories often extend the process much longer than necessary simply because they file repeated motions or refusals that the court must address one by one. But even with all of those delays, the final results tend to stay the same because the courts rely on established law and verified evidence. No matter how much time is added to the proceedings, the outcome usually aligns with the rules and facts of the case. So after years of back and forth, the situation still moves toward the same conclusion, just with a much longer path to get there.
A series of responses, as it were filed, the last of which is a response to plaintiff's counter-defendant's motion to strike, in which the defendant has a number of things, but the chief among them, in paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. And then in paragraph 8 in our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge. Oh, there's one other thing. Yeah, he suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our client, so my client corporation is not acting without an attorney, so that's irrelevant. So basically what I'm asking for is judgment in the amount of $18,610.79, in essence, because the defendant has agreed that he owes the money.
I have been noticing a pattern recently. In several of these cases, the individuals who insist they never agreed to any financial obligation end up accidentally admitting that the debt is in fact theirs. It usually happens while they are trying to argue a point that they believe supports their position, but the statement actually confirms the opposite. This is what tends to occur when someone follows legal advice taken from reliable sources or self-help guides that oversimplify complex procedures. Real law is detailed and structured, and misunderstandings can lead people to reveal information that directly works against their own arguments. IT is an interesting trend because the intention is to avoid responsibility, yet the explanations they offer often reinforce the very facts they are trying to dispute.
Campbell, your response?
I disagree, and I'll stand on my brief.
And you stand on your pleadings? Okay.
Which was
all right. The court's prepared to move forward in this matter. This is a motion for summary disposition filed on behalf of plaintiff and notice for hearing today. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that date, the court's register of action does not appear that any pleadings were filed by the defendant. Michigan Court Rule 2.116G4 is relevant here. A motion under sub-rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there is a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. No response was filed to the plaintiff's motion for summary disposition. However, in his earlier pleading, which is really not relevant because they were not, again, filed in response here, the defendant admitted that he owed the money. So that's going to be it. Court finds there is no genuine issue of material fact. Plaintiff is entitled to summary disposition as prayed for under MCR 2.116C10. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days of today in the Wayne County Circuit Court.
All right, so that wraps up the first loss on the list. It was a rough outcome, but it sets the tone for what comes next. Now let us move forward to the second major setback in this lineup. The pattern continues as the next case brings its own series of missteps and misunderstandings that lead straight to another unfavorable result. Each hearing shows how quickly things can go downhill when the legal arguments are built on ideas that do not match the actual rules and procedures.
We are on the record. We're calling file number 22198-398. The file is entitled Portfolio Recovery Associates versus Marcus Campbell. Your appearances.
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722.
And what is your name, sir?
Marcus Jamel Campbell in special appearance for.
In special appearance for what, sir? You filed an answer here. All right.
Marcus Jamel Campbell, special appearance.
I am willing to bet that his so-called memorandum of law was not prepared with the level of care that a real legal filing requires. A memorandum can be used as a response to a motion for summary disposition, but it must clearly lay out the specific rules that apply in that court. That IT should explain why summary disposition does not fit the facts of the case, and it must show how the legal standards in that jurisdiction have not been met. On top of that, it needs proper citations, including case law, statutes, and established legal authority that supports the argument being made. If he manages to meet every one of those requirements with accuracy and structure, then that would be a truly surprising achievement given how little preparation seems to be behind his filings.
Mr. Campbell?
I'm not sure if I have, but I'm wondering if you all have my paperwork. I'm not sure if I did.
I have a motion filed by Mr. Campbell. My question is, did Mr. Kirschenheiter, did you receive his motion?
I perceive so.
Okay, so you got the motion for summary disposition filed by the plaintiff. Mr. Kirschenheiter, did you get the motion filed by the defendant?
Your Honor, I'm not exactly sure what we received. It just says brief and memorandum of law.
Yeah. Okay, that's fine. We have that. Now, Mr. Campbell, my question to you is that your answer to the motion for summary disposition?
Yes, it is.
That is your answer.
Right.
Well, that is simply the judge using professional language to express that the argument being presented has no real grounding in law or logic. Judges often phrase things carefully, but the meaning is still clear when someone is completely misunderstanding the process. At least this time the situation ends without me having to make good on any exaggerated promises or unusual predictions, because the outcome speaks for itself. It is another moment where the court remains patient while someone continues to push ideas that cannot stand up to even basic scrutiny.
Okay, so then neither side wants any discovery, and all I need to do is calendar your motion. Is that what you're both telling me?
Yes, long as
Okay, here's what we'll do. The court will calendar for May 1st at 11 o'clock, plaintiff's motion for summary disposition. We will receive Mr. Campbell's pleadings denominated brief and memorandum of law and proof of service as the answer to that motion. This is 22198-398, Portfolio Recovery Associates versus Marcus Campbell. Date and time for a motion for summary disposition. Could I have your appearance?
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir?
Marcus Campbell in special appearance.
Mr. Werber.
Yes, Your Honor. Today's the date and time set for plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was a Care credit card issued by Synchrony Bank. It was opened up on November 29, 2018. As the invoices attached to the motion reflect, the last payment made on this account was June 30th, 2021. At the time of charge-off, it left a balance of $3,171.94, the exact amount the plaintiff filed the lawsuit for. Those monthly invoices were all mailed to the defendant at his current address, which he placed on his answer and his response to the motion for summary disposition. Defendant made payments on this account for almost 3 years and has not shown that he ever objected to those monthly invoices that he received in the mail. He filed a general denial answer and a lengthy response to plaintiff's motion, but neither provide this court with the genuine issue of material fact or a true defense to this motion. So plaintiff requests that the court grants its motion for summary disposition today.
Mr. Campbell.
Yes.
Your response, sir.
I sent a brief regarding the denial.
Yes, the
No.
court has had the opportunity to read your brief, and I thought it was an interesting set of matters that you set forth here.
So at this point, he is down 2 losses in a row, and it is starting to look like a pattern that even he cannot talk his way out of. Watching these hearings back to back really shows how consistently he walks into each one with the same failed strategy. Now we are heading into his 3rd attempt, and you can almost feel the audience hoping that this round will at least deliver something new or entertaining. For everyone observing the case progress, the 3rd appearance starts to feel like the moment where the final outcome becomes obvious. That it is the classic situation where a person keeps repeating the same approach expecting a different result while everyone else can already see exactly where it is going.
But I'm prepared to rule on this matter. Is there anything else you want to say in addition to what was filed?
Right. I have not contracted with them, and I do not wish to contract with them now. I just want to make sure that the brief is on the record, though.
I see your brief and memorandum of law and proof of service.
Yeah. So all of that is on the record.
I see it's
That's all I-
filed here, and I see
Yes, sir.
all.
That's all I don't know.
I know, for example, that you cite federal rules of civil procedure. I
Right.
know, for example, that you cite 28 USC 2403. I
Mhm.
further note, you cite MCR 2.614. Okay, I'm prepared to rule.
Yeah.
Having had an opportunity to read the pleadings both by Mr. Werber and by Mr. Campbell, the court is satisfied that there is no genuine issue of material fact. The motion for summary disposition under MCR 2.116 C10 will be granted. I'll send you gentlemen out of order. Did you attach an order, Mr. Werber?
Yes, Your Honor, there is an order attached to plaintiff's motion. It's right before all the exhibits.
I see it. I see it. All right, the
Right.
court will enter that today. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court.
So let me make sure this is crystal clear. You are asking the people you still owe money to pay you a personal fee for trying to recover the very funds you never retained. That is a level of backwards logic that almost defies explanation. That IT takes a remarkable amount of confidence to demand payment for a situation you created by refusing to honor your original agreement. Most people would focus on resolving their debt, but instead you are trying to turn it into a profit opportunity. You should genuinely be relieved that the world around you does not issue its own penalty list every time someone misuses time and resources. Because if that were the case, you would owe far more than anyone is currently asking from you.